Hearing in the Queen on the application of Jalloh against Secretary of State for the Home Department.
Good morning, Mr. Tan.
May it please the Court. In this appeal, I appear for the Secretary of State for the Home Department, together with learned friends Matthew Gullick and Emily Wilsden. And representing the respondent, Mr. Jalloh, is learned friend Dinah Rose of Queen's Counsel and learned friend Jude Bunting. Lady, can I just start at the outset by saying that the respondent is not anonymised. There's been correspondence about that. There has been some confusion over his name during the course of the proceedings, partly because his identity and his true name remain in dispute, and partly because the previous solicitors who acted for him at one stage misspelt one version of his name when issuing proceedings. None of that matters because his true identity is irrelevant for the purposes of the issue in this case, but I mention that for completeness. It's a slightly unusual case for the Secretary of State in the immigration field because it's a false imprisonment claim which these days is not itself unusual, but the central issue is not one of the usual public law questions that were brought to prominence by cases such as Lumba, but the pure tort question really of whether the respondent was imprisoned for the purposes of the tort. And it may be a bit of relief to the court to know that Lumba is not, for a change, not actually even copied in the authorities' bundle. The authorities that we'll be looking at
Deeply insulting, then.
We're terribly disappointed, yes.
Even I couldn't bring myself to find a requirement for that. The authorities that we will be looking at are of a different nature, really. What I propose to do in the 2 hours that I have is to divide my submissions basically into 5 sections. The first is to give the court an outline of the central facts and to show the court that the documents in issue that relate to the curfew that is at the centre of this case. The second, I will take the court through the evolution of this issue through the various cases before and contemporaneously with this one. The reason for that is that it shows the court that this issue has not actually really been considered in detail until the Court of Appeal looked at this issue in this appeal. And now that it's before this court, we apprehend that this court will make up its own mind about the legal issue. The third is to spend a little time actually looking at what happened and how the respondent responded to the curfew requirement that was made of him. Because we say that a proper understanding of what he was doing is absolutely critical to understanding where or on which side of the various dividing lines his case falls. And so it will be necessary to spend a little time looking at the detail of that. Then I will take the court to the most important case law on false imprisonment. Some of it is quite old, but that reflects the fact that this particular corner of the tort has not really been looked at in the past, and so we'll have to look at the authorities and see what they say.
So that's point 4, is it?
That's section 4.
Yes.
And then section 5, there will probably be a few sweeping up points at the end of that. And then at section 5, I will deal briefly with the Article 5 issue. As we've set out in our case, logically, it comes prior to the main issue, because you have to understand whether the alignment is going to take place before you decide whether or not he was imprisoned. But as I hope is clear from our printed case, we see that although the issue is technically open, there are arguments both ways, and I will deal briefly with those by way of inviting the court to examine that issue. So can I turn to the first of those sections, what the restraint actually was in this case that was said to constitute imprisonment. It was a condition of the respondent's temporary release from immigration detention that he abide by a curfew. By way of background, perhaps if I can give the court a few dates. These are, in fact, set out in the Statement of Facts and Issues at paragraph 6, that's MS 84. The relevant deportation order was actually made as far back as the 21st of July 2008. It's immaterial, but he was detained for a period after that, and then he was released thereafter. That deportation order was revoked on the 22nd of September 2015 for reasons which don't concern the court. But I mention that because it does fall within the period of the curfew that is complained of here. So the legal basis of the restrictions, or the purported legal basis of the restrictions, did change. That doesn't affect the outcome of the case, but it is right that I should draw the court's attention to the fact that there was a change at that point. And then after the Times material to this appeal, on the 20th of December 2016, a new deportation order was made, replacing the one that had been revoked. So all through this time, there were deportation proceedings on foot. More pertinently, during the course of 2013, the respondent was convicted of an offence of child cruelty and sentenced to 12 months imprisonment. So he then went into criminal custody to serve his sentence of imprisonment. As it happens, that was very brief because of time already served. And then on the 16th of April 2013, he went into immigration detention. I should say this is set out in paragraph 7 of the Statement of Facts and Issues. He remained in immigration detention until the end of October 2013. On the 29th of October, the first-tier tribunal granted him bail. And at this point, could I ask the court, please, to turn up in Appendix 2, page 254, this is MS 401, because you'll see there the grant of bail by the tribunal on the 29th of October 2013. In the middle of the page, you'll see that one of the primary conditions of bail is that the applicant is to appear before an immigration officer within 48 hours of being released. In fact, the respondent did that on the next day, the 30th, and as we now understand, the legal effect of that was that the tribunal's bail came to an end, and the respondent was thereafter subject to whatever restrictions were imposed by that immigration officer. The restrictions that were first imposed are found at page 256 of Appendix 2. This is MS 403. And it's a notice, in fact, you'll see on the top of the next page the date of the 30th of October, addressed to the respondent, and says the Secretary of State has decided that you should not continue to be detained at this time, but under paragraph 2.5 of Schedule 3 to the 1971 Act, she now imposes the following restrictions on you. So he was to report to an immigration officer at a specified reporting centre, and then the timetable for further reporting was set out. It was Mondays, Wednesdays and Fridays between 10 a.m. and 4 p.m. Unless varied. It required him to live at a specified address. He was to be monitored electronically by means of tagging and tracking. And then there was a requirement that he should be at home for induction when the electronic monitoring was to be installed. And then at condition 6, following induction, so this curfew, this curfewed condition did not take effect until induction taken place. So following induction, you must be present at the address shown above between 2300 hours and 0700 every day, and every day thereafter. And that, therefore, is the curfew condition with which we are concerned. As it happens, actually, before I move on, I should draw attention to the warning at little 2 at the very bottom of that page, that if, without reasonable excuse, you fail to comply with these restrictions, you will be liable on conviction to a fine not exceeding level 5 or 6 months imprisonment. Yes, or both. That I think reasonably fairly sets out the terms of the possible criminal offence, but subject obviously to all the usual defences, including the explicit one of reasonable excuse.
You'll be coming on to tell us what a reasonable excuse is, will you?
He wasn't in fact prosecuted, so no issue of whether or not he had a reasonable excuse has arisen in this case, but there was always that express defence available to him if he were ever prosecuted for failing to comply with the conditions. What actually happened was that there were problems about getting him inducted, and the induction did not actually happen until February of 2014, so some 3 months later. You'll see this on MS 405, that's Appendix 2, page 258. There's a similar notice of restriction that was given. This one is dated the 30th of January 2014. You see that at the top of the next page. And there was a requirement to be at the address...
I'm so sorry, you skip between page references. Sometimes it's in the hard volume, sometimes it's in the MS.
Yes, I'm sorry. This is Appendix 2, page 258. It's MS 405.
Thank you.
Sorry, 405.
405, yes. I'll try to remember to do them in that order so that it's clear. There was a different home address specified at paragraph 3, and then the requirement to be present for induction on the 3rd of February, and then following induction, the curfew requirement between 11 p.m. and 7 a.m. So that was when the curfew actually took effect. Appendix page 260, MS 407, there was a further notice of restriction which I don't think contains any material differences, but I just draw that to attention. This curfew then remained in place until these proceedings were issued, and an interim relief application was made to Mr. Justice Collins on the 14th of July 2016. If you can turn back in the appendix to page 143 or MS 290, you will see the order that Mr. Justice Collins made lifting the curfew and ordering that the Secretary of State should take no steps to enforce the curfew. So that was the terminal date of that. Having shown you those core documents, can I just briefly show you the statutory provision that was the cited power for this curfew? This is in Authorities 2, tab 22. It's MS 761. This is Schedule 3 to the Immigration Act 1971, paragraph 2. This version only actually covered the last couple of days, but for our purposes that doesn't matter. The relevant parts were either in this form or in broadly the same form. Paragraphs 2 and 3 were the detention powers. I think the court's familiar with those from cases. And then paragraph 5 was the power that was cited as the power to curfew, which a person to whom this subparagraph applies shall be subject to such restrictions as to residence, employment or occupation, and as to reporting to the police or an immigration officer, as may from time to time be notified to him in writing. And then 6b makes that apply to somebody in the respondent's position. Now, we accept, following the decision of the Court of Appeal in a case called Geddy, which I will come to a little later, that although this was the power that was cited for the curfew, it did not, in fact, allow the Secretary of State to impose such a curfew. And so the curfew requirement that was made without lawful authority. The effect of that is that if, and this is the real question in the case, if the curfew or the effect of the curfew amounted to imprisonment, then the Secretary of State cannot rely on this power as lawful justification for the imprisonment. And that is why the question in this case turns entirely on whether the curfew requirement amounted to imprisonment for the purposes of the tort. Well, I should stress, though, that it therefore follows that when looking at that question, it is entirely irrelevant whether or not there was any lawful justification. The question of imprisonment really stands entirely independently of lawful justification, and we accept that there was none in this case that we could cite. The logical consequence of that is that the Secretary of State is therefore in exactly the same position as any private individual who made a similar requirement of somebody else, because questions of statutory power and so on have just completely gone out of the window. And we respectfully say that that is an important thing to bear in mind when looking at the cases and considering where the dividing lines are for the definition of imprisonment.
Well, except that the Secretary of State has the full panoply of the state, apparently, behind his requirement.
That is one thing which may have a bearing on it. But one of the examples that we've cited at paragraph 2.6 of our case, that's at MS 94, we've actually given three hypothetical examples of situations in which a requirement or an instruction might be given to somebody by a private individual. The first of them is perhaps a fairly common case of a shopper who's suspected of shoplifting. But rather than the classic case of that is that they're told to remain where they are because they're being investigated, and they say they've been imprisoned because they're then immediately detained by, say, the store detective. But it's not impossible that a shopper might be told just to stay where they are while a police officer is being fetched. So then they're not told that they're now under the control of the store detective, but they are told just to remain where they are. The second example is...
I'm sorry, but surely the critical issue is whether the will of the individual is overborne.
Yes, my Lord has identified exactly the central issue in the case. Is the will of the individual overborne?
Well, that could occur by compliance with an instruction, could it not?
I accept that it could, and that there are situations, we'll see from the cases, where an individual's will has been held to have been overborne. But it requires, we say, a total restraint or total or complete control over the individual, overbearing their will. And the reason why I will spend some time looking at what actually happened in this case is that is not a characterization which can fairly be put on this respondent's actions whilst the curfew requirement was in place. To put it in a nutshell, he often chose to go out. And if he didn't choose to go out, we say the corollary is that he chose to stay in. This was a situation where the question of whether he went out or stayed in was always of his choice, and his will was not overborne. It was never overborne.
Well, it depends. You can't look at this in a sort of panoramic way. There may be occasions when his will was overborne, and other occasions when he decided that his will was not good to be overborne. I mean, it's not something that one can say, looking at it in the broad panoramic way, that because there were occasions when he decided not to comply, that it meant that he didn't submit on other occasions. Can you?
In theory, I can see the force of what your lordship puts to me. But again, this is one of the reasons why we will need to look at the facts of the case, because it's we would say quite inconsistent with that proposition well, rather, his actual actions were quite inconsistent with that proposition, because he was a person who clearly evinced an ability to choose for himself whether he was going to go out or whether he was going to stay in. It's also, I have to say, in a sense, overlaid by a difficulty which is always present in these cases, that if the curfew is an overnight curfew, the individual, in fact most of us, would normally be home for many of those hours, just in the ordinary course of life. So being at home between 11 p.m. and 7 a.m. is something that one might simply do from normal routine without there being any influence at all from the curfew requirement that was imposed.
Sorry, forgive me, I'll stop asking questions after this, but if I've understood your thesis correctly, someone who is a faithful adherent to the regime that's imposed by the order and does not break it at all would be the victim of false imprisonment, whereas someone who evinces an intention from time to time not to submit to it would not be a victim of false imprisonment. Is that right?
Well, I wouldn't accept that the first of those propositions with respect is necessarily true, because the person may simply be at home because that's what they normally do.
Well, let's suppose that person said, well, the reason I was at home, I wanted to go out, I wanted to do all manner of things, but because I was subject to the restriction order, I felt constrained to stay at home, and I complied faithfully with the terms of the order. Would such a person be a victim of false imprisonment?
We would say that even in that situation, it would not amount to false imprisonment just simply from that, because the person is not it's not false imprisonment if the person is merely complying. What is needed for imprisonment is complete overbearing of the will. So the person says, I had no alternative. This was the only option open to me to stay in. And in a situation where, like this respondent, they're at home and there's no lock on the door, or rather whatever lock they can operate, they can walk out of the door at any time, that is still not total control. So simply saying, well, I complied with the requirement is not enough.
But if they say, well, I didn't want to expose myself to the sanction of whatever the fine is, plus 6 months imprisonment, and that's why I did not go out to do the things that I wanted to do, would that be false imprisonment?
Well, we would say it would really require a lot more than that. I don't think I could exclude the possibility that somebody who was so terrified of authority that the instant any sort of requirement is made of them, that they feel that they really have no option but to do exactly what they are told.
Well, I must stop now and let you get on with it, but this is certainly a very interesting area.
Lord, yes, and that is why even the Court of Appeal in this case said, if you look at the cases, there are some very fine distinctions involved here, and we will draw attention to them. The second of the examples that we cited is again a shopper, but the shopper's on an upper floor of a shop, and there's something has happened below, and the staff say, don't go downstairs. They don't do anything to restrain the shopper from going downstairs. They say, don't go downstairs, stay where you are here. So again, that's another example of an instruction given to an individual, given by one private individual to another private individual. And then there is the example of the prankster, and we cite the prankster because if the prankster is dressed up as a police officer and drives a car that purports to be a police car, then the prankster would also have, apparently, the panoply of the state behind him, drives up and down the street and using a loudhailer instructs everybody to remain at home because this is what regulations require them to do. And all of this is false because it's just a prank. And whatever the answer is in our case, is also has to be the answer in a case such as that, because the Secretary of State is really in no different a position from a private individual, accepting that there is the apparent backing of state power from a private individual who disguises himself and pretends for that. And there is actually one more situation which is relevant, and this comes closer to the situation here. I've drawn attention to the reporting requirement that was imposed. Now, as it happens, the reporting requirement appears to fall foursquare within the power, so there's no difficulty with lawful justification there. But the reporting requirement requires the individual to go from wherever they are, typically they might start from home, to travel to a certain place and to be there for however long it takes to comply with the reporting requirement before they travel away and perhaps travel home. In principle, that sort of requirement to be at a particular place at a particular time and to travel there is no different from a requirement to be in the particular place, namely his home, during certain hours. So whatever the result for our case also has to work for that. If it would be imprisonment for a curfew, it would have the result, it would seem, that complying with a reporting requirement also involves imprisonment for the purposes of the tort, both at the reporting place and also for the course of travel. So this is why we say, whatever the answer is, it has wider ramifications than just the apparent you imposed a curfew with no power. It has broader effects than that. Can I then turn to the second area, which is to show you the evolution of this issue over time, because this will also explain the slightly convoluted procedure by which we got here. The issue was first raised in the curfew case of Geddy before Mr. Justice Edis. This is in Authorities 1 at tab 9. It's MS 575. The main issue in the case was whether or not there was a power to impose tagging and curfew at various times. To cut a long story short, there were 4 periods. The period 3 was conceded to be without power. And Mr. Justice Edis concluded that in periods 1, 2, and 4, there was power to impose these. So when he looked at the question of false imprisonment, it was for period 3 alone. You will see the conclusion in relation to periods 1, 2, and 4 at paragraph 59, MS 597. The claimant's challenge to the imposition of the curfew in periods 1, 2, and 4 fails. And then at 65 on the next page, MS 598, he then looked at false imprisonment. So during period 3, for nearly 4 months, claimant was subject to curfew and tagging when he should not have been. Letters to enforce the curfew were sent, but he was not arrested and not otherwise punished. Mr. Justice Edis says, I've been addressed as to the law by reference to Clark and Linsell. Both sides accept that it accurately states the law. It's paragraph 1523 to 1528 that he was referred to, and at 67, he specifically cites 1523, and he said he used the expression house arrest. So he concluded that the elements of the tort were made out during that period. Now, of course, on the basis of the argument before him, he was entitled to come to that conclusion, but I think I'm equally entitled to say that it was really rather brief argument. It certainly didn't look at the underlying authorities, and the approach that he took, and in fact I think has really been taken in all the decisions so far, was to look at this as a question of principle a panoramic view, if I may respectfully adopt that phrase, rather than looking at each individual instance. And so it was not a decision which really sheds much light on the detail of the argument. Geddy went to the Court of Appeal. You see that in the next tab, tab 10, starting at MS 599. Again, to cut a long story short, the Court of Appeal disagreed with Mr. Justice Edis about the power to curfew and about lawfulness. And then they then went on to look at false imprisonment. There was, however, a procedural mishap for which I bear responsibility. You'll see this set out at paragraph 39 on MS 607. They said that with regard to whether the appellant has an action for false imprisonment, Mr. Justice Edis decided that the appellant did have such an action in relation to period 3, where the Secretary of State conceded that there was no lawful justification. Although there was neither a cross-appeal nor a respondent's notice in relation to the other 3 periods, Mr. Tam sought to challenge the finding on the basis that it was raised in the skeleton argument and did not therefore take the appellant's counsel by surprise. The failure to comply with the CPR cannot, however, be sidestepped by reference to skeleton argument, and we are not prepared to deal with the argument in the context of this case. They then noted the proposition, and they, at 40, they say they weren't going to go behind that or the inevitable impact of the conclusion, but they didn't want it to be thought that their decision was any authority for it. So Mr. Justice Edis's decision stood for the procedural reason, but the Court of Appeal in Geddy didn't actually look at it. And that was then how the issue then came before Mr. Justice Lewis in this case. The court will know that he gave 2 judgments in this case for reasons which he then explains. The first of the judgments is in Appendix 1 at page 25. It's MS 172. At that time, the respondent was represented by Tom Hickman and learned friend Mr. Bunting. At paragraph 3, Mr. Justice Lewis identified what were the preliminary issues, or 2 of the preliminary issues that had been ordered to be tried. And it's little 2 in paragraph 3, this is MS 173, whether the imposition of an unlawful curfew constitutes a false imprisonment, and whether Geddy should be followed on this issue. He said that the anticipation of the parties, it seems, was that the question of the quantum of any damage to false imprisonment, if the imposition of a curfew constituted the factual element of imprisonment necessary for that tort, and then also misfeasance, be dealt with at a later hearing. It transpired that this approach to the litigation has not proved satisfactory. First, whether because of the way in which the litigation has been constructed or for other reasons, the relevant facts in this case have not been established. Secondly, there will, in any event, need to be a further hearing to establish the facts and deal with the misfeasance claim and assessment of damages. But be that as it may, he did deal with the issues that had been ordered to be tried. At page 30, appendix page 36, MS 183, is the beginning of the section of his judgment that deals with that. He sets out the issue, he sets out the claimant's case in some detail, paragraphs 34 onwards, and then from paragraph 41 onwards he sets out what our argument had been, and at 44 you'll see that he mentions and cites a significant number of authorities which we do have. But at the end of that paragraph, he says, it's not necessary for this court to consider in detail the facts and the ratio of each of these cases. And the reason for that, if you go over to page 40, MS 187, is that he decided that he should follow Mr. Justice Edis under the principle in ex parte tal. Ex parte tal is cited at paragraph 46. and he explains that. And at 47, he says, applying those principles here, I'm not convinced that the judgment of Mr. Justice Edis was wrong, nor has any powerful reason been advanced to justify this court not following that judgment. He then sets out a number of reasons for that, but it does have the effect that these authorities were not looked at, or his reasoning, or we don't have his reasoning about those authorities. That was the basis of his decision. So that was February 2017. There was a listing of the second hearing in June 2017. At that stage, the respondent had lost his legal aid, as a result of which the case was adjourned till October 2017. And at a 3-day hearing then, it was heard with another case, but the hearing was a 3-day hearing. I should say that at that stage, the respondents was represented by Declan O'Dempsey and Navid Pourgazi of counsel, who'd taken the respondent's case on a pro bono basis and done a substantial trial for him, dealing with the facts. You see this set out on page 45 of the appendix, MS 192. And this is the judgment in...
Sorry, did you say 112?
192.
192, sorry.
Yes.
This is his second judgment on the facts.
That's right. This is Mr. Justice Lewis's second judgment on the facts, and he then dealt with the facts in some detail. I'm not going to do that now because I'm going to have to come back to this. But the conclusion was that he awarded the respondent £4,000 damages for false imprisonment, having already in his first judgment decided that the curfew amounted to the tort of false imprisonment. The Secretary of State appealed to the Court of Appeal on liability on that false imprisonment issue. The respondent cross-appealed on quantum, and the Court of Appeal dismissed both appeal and cross-appeal. I should say that there are two versions of the Court of Appeal order in the bundles. The correct one is at MS 52. I'm not quite sure why the first one managed to get sealed, but we have traced it through, and I think we're all agreed that the correct one is at MS 52. It's also the first tab, I think, in the additional bundle that you have, but I don't need to turn that up now. In the end, the Court of Appeal's judgment was actually therefore the first time that anybody looked in detail at the arguments and the authorities on this point. We have set out in our case a detailed critique of the way that the Court of Appeal approached it. Given that we apprehend that this court will make up its own mind on the authorities, I don't think I need to spend any time orally going through that, but I'd noticed that I need to draw attention to it. There are two other cases that were going on, I think, contemporaneously, which I should mention, which touch on this issue, but really don't take it any further. The first is a case called MS, which is in Authorities 3, tab 38, MS 1416. This is a case which involved not a curfew condition, but a condition of having to have, might describe it as sufficient residence at the residence as a condition of leave. Just a second. I think that the condition in question is at MS 1420. Sorry, it's paragraph 11 of Mr. Justice Collins' judgment, MS 1420. And there was a definition of residence which was not to spend more than 3 consecutive nights away from the address without the Secretary of State's consent, and not to spend more than 10 nights away in any rolling 6-month period. And the argument was that because that affected how long one could be away from the residency, it amounted to false imprisonment. At paragraph 30, which is MS 1427, Mr. Justice Collins turned to that part of the argument. You'll see that paragraph 30 that Geddy was relied on, and 32, Mr. Justice Edis's first instance decision is set out, and after the short quotation from Clark and Linsell, Mr. Justice Collins' comment was, "It is easy to see why a curfew, breach of which constitutes a criminal offence, falls within that definition." So there was no substantial argument before him about that. His actual decision was that as far as the condition with which he was concerned, that was clearly not imprisonment. So this decision really does not take matters any further. And the last authority is the same bundle, Authorities 3, tab 43, MS 1550. It's a case called W, decided by Mr. Justice Dingemans. At paragraph 51, I should say, it concerned a condition to the same effect as in MS. At paragraph 51, Mr. Justice Dingemans looked at the question of false imprisonment. Sorry, I should say that's MS 1561. Again, he cites Clark and Linsell and then refers to decisions in G and MS, and there's no substantial discussion of the authorities there. So that's how we get to where we are, with there having been very little detailed consideration. Can I then turn to the third part of my submissions, which is the question of what actually happened in the respondent's case. It's agreed that there was no barrier to prevent him leaving the house. There was no lock, or no lock that locked him in, that prevented him from going out. There was no guard to prevent him going out, and he was physically free to come and go at any time, including during the curfew. So compliance, in one sense, was entirely a matter for him and what he chose to do. On the facts of his case, his compliance was far from complete, and the pattern shows that he rather picked and chose when he would comply. There were, in 2014, so in the relatively early period of his curfew, some agreed variations that allowed him to stay out late during Ramadan, but there weren't any further agreed variations after 2014. I think that, well, perhaps if I give you the figures all in one place, this will assist a perspective. The curfew was in place for 891 days, or perhaps one should say nights.
This is all in the SFI, isn't it?
It is, but I can just give you these so that they're readily to hand. On 31 nights, that was varied to shorten the duration. There were 37 nights when the respondent was away for the whole night. So he literally was not at home at all.
Without permission?
Without permission, yes, without permission. And then on 108 occasions, he was away for part of the night.
There were 29 of those 37 were his family court proceedings, were they?
Yes, I think that's right. Certainly most of them were for going to the family court. In a sense, we say that doesn't actually matter. The point is that he wanted to go to the family court, so he just went.
But I mean, did anyone do anything about that? I mean, presumably the whole point of tagging is someone knows what you're doing.
Well, I think one of the things that would happen, I can't tell you how consistently it happened, but there would be warnings sent to him, but there was no actual enforcement by either arrest or prosecution.
Well, it's surely some importance. I mean, if you actually go out on 37 different occasions and no one says anything, well, then you may reasonably feel you're not being constrained. But if you're getting letters saying, if you do this again, you'll be prosecuted, then it's rather different, isn't it? Yes. We have no evidence of what actually was.
My Lord, there is evidence. So, the evidence was that he was telephoned. There was a telephone in his bedroom that was attached to the tag, and the evidence was that he would be phoned if he wasn't at home during the curfew. And his evidence was that, in fact, on occasions there were malfunctions in the tag, and so he would be asleep at home and he would be phoned by G4S, who would accuse him of being outside the property. Yes, I can show you, Lordships, in the transcript in due course.
Sorry.
Yes, certainly that was immediate response that he would get. Of course, if he was not at home, then he wouldn't know whether or not he had been phoned. But in terms of enforcement in the sense of arrest or prosecution, that didn't take place more formally. As I say, I think that there were occasions when letters were written to him. Of the 108 nights of part absence, there were about half of them, 57, were over an hour, and sometimes that would be quite a substantial number of hours, and then the remaining 51 were less than an hour, but with a good spread throughout that range. So if one is looking for raw figures, about 16% or so of the nights of the curfew, he did not fully comply, or sometimes not comply at all. Now, the raw statistics, of course, can be misleading. One of the things that we do have the benefit of in the papers is a detailed pleading which was done at, I think, Mr. Justice Lewis's behest between the first and second hearings, setting out exactly when the respondent claimed that he was falsely imprisoned. This is in Appendix 2 at page 145. It's MS 292. You see that these are the amended grounds for judicial review pursuant to the order of Mr. Justice Lewis dated the 1st of March 2017. The particulars of false imprisonment, which set out the detail of the pattern, start at page 155 of the appendix, MS 302. And the particulars of false imprisonment you see there are listed seriatim. Where the respondent was at home for the whole of each curfew period, you see that that is pleaded as false imprisonment between 2300 and 0700. But where he was not fully compliant, then different hours are pleaded. And so that we're not spending a huge amount of time going through all of the detail of this, can I draw attention to a number of points in here, so I can do several things in one go. If you can go on to Appendix 158, MS 305, you see that paragraph 33A29 deals with a number of nights consecutively of full presence during the curfew hours, up to the morning of 17th of June 2015, and then he was indoors between 2300 and 2327 on the 17th of June, and then he goes out for 35 minutes and then comes back in at 01:02. So this is during the curfew period. He's obviously free to do that. On the next day, he's simply out until 01:22. The next day, 00:59. The next day, 00:44. Now, I think from memory that this was probably during Ramadan, so he would have likely cited religious reasons for it. But it demonstrates...
Is that accepted as being a reasonable excuse?
I don't know what the answer to that would be if he was prosecuted and he said it's a reasonable excuse for me being out, because that's never been tested. So
No, but I mean, you would be the people who would be doing the prosecuting, or at least instigating it. There must be a view as to what would be a reasonable excuse, wasn't there?
Well, I don't think I can give an answer to that question. I wouldn't like to...
I mean, sure, he's entitled to know whether if he leaves to go to Ramadan, that is something which would risk prosecution or not.
I suppose there are various issues that would arise, whether or not it was reasonable for him to seek prior authorization and so on, and the reasons that he didn't. So it would be a sort of a factual inquiry, I suppose, into the circumstances.
That's right, and I apprehend that if the issue were to arise in the context of a prosecution, there would be quite a lot of issues like that that would bear on the question of whether there was a reasonable excuse for not complying. But we say that that doesn't really bear on the question of whether there was a total restraint when he was not out at his Ramadan celebrations. What is relevant is that when he wanted to be there, he was there, because he just either left or he just stayed out late and came home late after the curfew period had started. That is what goes to the question of a total restraint.
And do these dates here in this pleading signed, I see, by Philippa Kaufman, among others, do they correspond to the numbers of days that you've given us in the statement of fact?
They should do, because all of that was taken from the tagging records, as I understand it. Yes, which would record that. There were some disputes about individual dates, but broadly speaking, this is the pattern that is shown. On the following page, just to identify other instances, there is 33A46, halfway down the page, 6th of July 2015, a night when he both came home late and left early. Again, demonstrating, we say, the clear ability to do that. And
is this precise material all derived from the tagging machine?
Yes, I think it was. So it happened a while ago now, but there was a lot of work done on those records that then produced a spreadsheet, and then I think worked its way into this. Yes, I see Mr. Bunting nodding.
Sounds pretty obvious, really, doesn't it?
Yes.
What's it there for if it doesn't actually record?
Well, as far as the litigation is concerned, one of the things I'm always grateful for is dedicated and industrious juniors who are doing all of this and collating all the information into this form. And
here were we thinking that you'd poured over every record, Mr. Tam.
Can I draw attention finally to what is on Appendix 163, page 310. The entries at point 105 and point 106.
Sorry, could we have the MS?
Yes, sorry, MS 310.
All right, thank you.
I'm sorry, the hard copy was...
163.
Thank
you. There was an apparent absence from home between 02:55 and 03:25. as to which the respondent's witness statement had actually admitted that he was out. So if you go on to Appendix 292, MS 439, you'll see that paragraph 59, there's actually an unequivocal acceptance that he was in breach of his curfew. In fact, if you look at paragraph 62, you see that he says there were a couple of times I went out at around 3 in the morning, so that would be consistent with that. But when the respondent actually came to give evidence in the second hearing, he was less accepting of this. Without reading it all out, can I just show you Appendix 2, page 310, MS 457. At letter E, I started asking him about that precise event. And then over the following 2.5, 3 pages, he was rather, I can fairly say, fencing with me on that, rather than just unequivocally accepting it. And it is in that part that you will see references to the ringing him in the night, and so on, so if they thought the machine wasn't working. That is the sort of inquiry which would be necessary if there were a question of looking at every single occasion to ask if the compliance was as a result of the individual's will being completely overborne on that occasion. While we are in the transcript of the evidence, can I just quickly draw attention to page 317, this is Appendix 317, MS 464. Just below letter E, there's part of a long answer where he deals with Ramadan. Dealing with family court proceedings and with Ramadan. Letter E, he says, my family care proceeding was going on for like 2 to 3 years. I always have to go to the court. It's a complicated case. We write to the Home Office. They don't respond back. And then my solicitors say to me, Mr. Jalloh, go. Ramadan time, even if I wanted to go to prayer, my solicitor said to me, go. And my solicitor just say to me, just go. So that would be consistent with the occasions, certainly on which he was absent for days at a time for the family court proceedings. I'm showing you this because it is the background to Mr. Justice Lewis's summary, really, of what happened with all of this. If you could go to Appendix 65, which is in the second judgment. This is after Mr. Justice Lewis has looked at the facts. At paragraph 75 on Appendix 65, this is MS 212. As part of assessing the damages, Mr. Justice Lewis says, it is important next to assess the actual effect of the restriction on the claimant. It did not, in fact, prevent him carrying out his religious observance. In June and July 2014, the curfew was varied to enable him to carry out his religious observances. The curfew was not varied in 2015 or 2016, but in fact, the claimant did carry out his religious observance, albeit that meant that he did not comply with the curfew that was said to be in force. The curfew did not, in fact, prevent him attending the family court proceedings, albeit that meant that he did not comply with the curfew that was in force. On the claimant's own evidence, the fact that he was subject to curfew did not in fact affect the outcome of the family court proceedings. So the only fair approach, we respectfully say, to looking at what actually happened in this case is that when the respondent was faced with a choice between carrying out the religious observance he wanted to do and complying with the curfew, he chose religious observance. And when he was faced with a choice between attending the family court proceedings, which he wanted to do, or complying with the curfew, he chose non-compliance. And every time that there was non-compliance, this is the pattern of what actually happened.
But it seems to have been because he was told by his solicitor that he should go.
Well, we don't...
Whereas the community gatherings and parties and so on, he clearly realised he couldn't go.
Well, we don't actually know the entire time period for which that answer covered. And to be honest, if you read the transcript, I suspect that we were never going to get any precision on that. But the fact is that wherever the motivation came from, whether it was his solicitor saying you should go, whether it was his own internal desire to comply with his religious requirements, his own desire to go and take part in the family court proceedings, he was choosing not to comply on every single
Yeah, but I mean,
occasion.
what is the clear picture that comes across is here was someone who realised he had to comply in relation to most things, was concerned about particularly Ramadan and family court proceedings, asked his solicitor and was given the assurance he could do those, and no one ever questioned it from the Home Office's side, so he no doubt went on that basis.
But when you look at the question of, was this a man who, when he was in his house during curfew hours, was there because he had no option but to be there, because the requirement that was made totally overbore his will, and that was the only thing that he felt he could do. And we respectfully say that if you look at all of these facts, what was happening was that when he was out, it was because he chose to be out. Whatever factors operated on that particular day, solicitor's advice or not, and so on and so forth, he was choosing to be out, he was choosing to be not in compliance. And when he was in, he was choosing to be in. And it would be a distortion of language and a distortion of the reality to suggest that when he was when he was in, it was because he was totally overborne by the requirement.
But surely it's a feature of the human condition that there are occasions when the threat of a sanction will overbear the will, and there are occasions when, notwithstanding the existence of the sanction, you are prepared to defy that and not allow your will to be overborne. Is that not so? And there will be days when someone will say, well, I want to go out, but I don't want to expose myself to the risk of a severe penalty, and therefore I will subjugate my will to the admonition or the mandatory command that I've received. There are other occasions when I simply can't submit to that. There's a stronger imperative, such as religious observance or my desire to ensure that I have access to my children, and I will defy it. I mean, it doesn't mean that because there are occasions that contrary factors impel one to ignore or defy the instruction, that there aren't occasions when you submit, however unwillingly, to the sanction. Is that not so?
Well, I think it, as always, it is dangerous to say never. But what we have here in this case is a clear pattern of ready and willing choice. And you can see from the way the pleading set out, it's quite a good day-by-day guide about how the choice to go out is made from time to time throughout the entire period of this curfew. It's not a situation where perhaps if I take an extreme where an individual says, I'm so frightened about what might happen that I'm never going to go out. And the only time that I did go out was because the house was on fire. And on that occasion, my will was no longer overborne by this unusual event. But it's very different. That's a very different situation from the situation where you have this individual who is from time to time throughout the entire period of the curfew, the time period the curfew was in force, going out some days and not going out at other days. And the curfew, as I said, is over the nighttime hours when he might just have been at home anyway, even if there had been a curfew. So what you get from this is, as we say, a man who goes out when he chooses to go out, and when he doesn't go out, it's because he's choosing not to go out. It is not consistent with somebody, pardon me, somebody whose will has been completely overborne by this curfew requirement. Can I, before leaving this part of the submissions, also just say a quick word about the potential consequences if he didn't comply, because it's right that I should set these out. There was a risk of arrest because of Section 28 capital A of the 1971 Act. There is a version in Authorities 2, tab 21 at MS 755, and I think that the extras bundle has a version which is more pertinent to the time of these events. Don't think it makes any material difference, but for completeness, that's there. And also a risk of prosecution under Section 24. The effect of that I've already summarised, but that section is Authorities 2, tab 21 at MS 750. And again, I think we have put a different version from a different time in the extras bundle for completeness.
Tab number in the extra bundle?
A moment, I'll find that. Section 24 is at tab 2 in the extras. Section 28A is at tab 3 in the extras.
Thank you.
And while I'm going through this at tab 4,
Yeah.
no, sorry, that's that I don't need to mention.
And the ones in the extra bundle, those are the ones that actually applied. Is that right?
They cover more of the period of the curfew. I'm still not sure that we've got every single one, but because the differences between them tend to be references to other statutes during that phase when there was, I think, a new Immigration Act pretty much every year.
There's no difference in substance.
No difference in substance, no. But the important thing about that set of consequences, and you'll see the relevance of this when we come to look at the authorities, is that if he was arrested, it would not be for the purpose of putting him back into his home. So this is not a clear deprivation of liberty to stick him back into the place where he was going to be detained.
So it's not like the sorts of powers that there are, for example, in the Mental Health Act, where if somebody is absent without leave from the hospital where they are detained, they can be recaptured by a wide range of people and returned to the hospital.
Exactly.
It's not that sort of power.
It's not that sort of power. And if prosecuted, it may or may not ultimately result in a sentence of imprisonment. But there are, of course, all those stages. There'd be consideration of whether the prosecution should be brought at all. There would then be the actual court proceedings, the question of whether there was a reasonable excuse, and even if he's convicted, the court would then have to decide on sentence. And if he was imprisoned, he wouldn't be imprisoned back in his home, he would be imprisoned somewhere else. So again, it's different from those mental health situations.
But presumably the curfew remains in place during all the time that those decisions are to be made, and so he's still obliged to be at home.
They might be in place. An alternative possibility might be that he would be re-detained under immigration powers.
Yep.
I accept that that is a possible consequence, but just as for arrest and prosecution, if he were to be re-detained, he wouldn't be detained back in his own home. He would then be taken to probably a removal centre or possibly to prison and detained there under immigration powers. There was, in fact, no power at all in the Secretary of State just to confine him back in his home if he was non-compliant with the curfew. And that is an aspect of imprisonment that was simply absent from this situation.
Just looking at the earlier part of Mr. Justice Lewis's judgment at paragraph 22 and 23, where he sets out the evidence of the claimant, and in particular paragraph 22, he tells us that the Home Office did on one occasion refuse to grant a variation for the purpose of attending Ramadan because he hadn't complied, but he seems nonetheless to have gone on attending Ramadan. And one sees at the bottom of paragraph 23 that he thought he ought to attend his mosque and family court proceedings in spite of being told he couldn't. Is that right?
Yes, that is right. Even though 3 lines up from the bottom of that page.
Can you give me the MS number, please?
MS 199.
Thank you.
He said he was worried that he would be detained or fined, but it didn't stop him from going on to do those things, choosing to go out for those purposes.
Yes, and the judge accepts that evidence.
Yes, that's right. Yes. We say that that's the element of choice in all of this. I don't want the court to think that I'm being unrealistic. I'm not suggesting that the requirement that was made had no effect on him whatsoever. We explicitly accepted in our case that there was a degree of constraint on him. But just the existence of a degree of constraint that might have influenced his actions is not enough, because it is that concept of total control, total constraint, that is needed for imprisonment, and that simply wasn't here because he was choosing to come and go if he pleased. Can I then turn to the 4th section, which is then to look at the primary authorities on this, to answer the question of what is imprisonment. I think that we've all got experience of fairy tales where some character says, "Help, let me out," which is the classic form of imprisonment. And when you look around at the situations in which the question arises, 99.9% are going to be something like that. There's actually no problem with the question of whether somebody's in prison. They're held tightly, they're locked in a room.
Rapunzel, Rapunzel, let down your hair.
So it has been. It hasn't been easy to find authorities which actually have any real bearing on this at all. The respondent accuses us of trying to propound some novel and restricted reading of the law at variance with some supposedly simple and easily stated rule. And the simple and easily stated rule they take from the textbooks in the way that Mr. Justice Edis did, just a paragraph from a textbook, and say this applies. We are actually not doing that at all, and right from the start, we have been absolutely clear about the approach that we've taken to this. We've started from the textbooks, but what we've done is to look at the authorities that the textbooks have consistently cited for the various aspects of the tort of false imprisonment. So these are the authorities that the textbooks themselves rely on. And then, obviously, those authorities work and work easily for the 99.9% of cases. But because of the unusual circumstances of this case and this type of case, once you actually go into the authorities and you look to see where the boundaries are, things get much more difficult. And that is why this is the approach that we ask the court to take, to look at these primary authorities, look at where the fine distinctions are, and apply them to this case. And in particular, I stress this over and over again, the central issue of whether the respondent's will was completely overborne, was he completely restrained by this restriction that had been placed on him. I'm not picking the phrase fine distinctions out of the air. I don't need to ask you to turn it up now, but the Court of Appeal itself in this case said at paragraph 58, that's at appendix page 17, MS 164, they said some of the decided cases involve quite fine distinctions and are sometimes not always altogether easy to reconcile. And we say that is not only true, but it is actually illustrated by the fact that in some of these cases, there were dissenting judgments and dissents amongst quite well-respected judges because the cases actually came close to the dividing lines in these situations. What we have done in our printed case is to set out 5 propositions and then to marshal the authorities under each proposition. But it's meant that a lot of the authorities are cited more than once, and the dynamic of an oral hearing means that it's probably not a good idea to try and do that. Instead, what I want to do is to identify the 5 propositions and then go and look at the cases, so hopefully we only look at each case once. The 5 propositions are these. First of all, that imprisonment requires a constraint on your freedom of movement. Classically, of course, that's by locking all the doors or by posting a guard to prevent your egress. Now, we accept that, of course, can include an imprisonment in the open air if the person is, in fact, not free to leave, or if he submits to that constraint. That's all on one side of the dividing line on this first proposition. On the other side, there are the contrasting situations where there is a mere instruction or a mere request to remain in a certain place, or where the individual voluntarily does something that could, in theory, be compelled by actual imprisonment. And also, on the other side of the line is the interesting situation where the individual is at that time free to leave his purported prison, even though, as soon as he does that, he'll be arrested and put back inside. Because that is a situation which on the authorities is also not, at that time, imprisonment. The second proposition is that if an imprisonment is constituted not by locks, not by physical locking in or barring, but by a constraint such as a guard, then that has to be a constraint which is intended to keep the individual in that place. Typically, if you've got a guard on the door, you can't lock the door, but the person is intended to be imprisoned there. As soon as he opens the door and comes out, the guard says, "Oh, no, you don't," pushes him back inside. So that's the second proposition. The third, what is really the central proposition in our case, is that such a constraint must be total. I should put that in quotes because that comes from the cases, or, quotes, complete, unquotes. It has to restrict the individual to that very space, and it has to be a total restriction, or as my Lord Kerr puts to me, overbearing his will.
But it doesn't have to be permanent.
Doesn't have to be
permanent.
No, it doesn't have to be permanent because, of course, if the constraint is lifted, then the person is then no longer imprisoned. I accept that. And it's always been common ground that even on the broadest approach to the respondent's case, he can only have been imprisoned during the times that he was actually in the house and the curfew, and it was during curfew hours. So both of those conditions had to be satisfied. But it has to be total constraint to amount to imprisonment. By way of contrast, it is not imprisonment if the individual wants to egress or progress in a certain direction, but is prevented from doing that and is stuck because he's met a barrier. But he could actually go in a different direction. A different direction he doesn't want to go in, but if he can go in some different direction, then he is not imprisoned. Or we would say, because there is a linkage between all of these, the constraint is not total or complete if he is able to leave to immediate arrest at that time. It's not total or complete if he's able to leave because he's not actually totally dominated by the defendant. And it's not total or complete if he's able to leave by a route which requires unlawfulness. None of those situations has that element of totality or completeness about it. The fourth proposition is this. The individual is not imprisoned if he is able to leave, even though the act of leaving would trigger an adverse response. And the fifth, as a separate proposition, although linked to the others, is that you're not imprisoned merely because leaving would involve you committing an unlawful act.
And by unlawful, you mean civilly and or criminally unlawful, do you?
Well,
some of the cases talk about it involving a trespass.
Yes, there is a case that does talk about trespass, but it wasn't specifically limited to that. And I think one would have to be a much better legal historian than I ever was to know whether or not that form of trespass would have been civil or criminal. The point is, you can't simply say.
Trespass has only become a criminal offence in recent times.
Yeah. Yes. Well,
It is, however, actionable per se. So,
yes. But the point really is that you can't just say, to get out of my prison, I'd have to do something unlawful. Therefore, I'm imprisoned. If you can actually get out, and that is the fifth proposition. None of these propositions would, on their own, solve the problem in this case, and they're all linked. So that's why you see them looking at different facets of the problem. But taken together, when you look at where the dividing lines fall, and applied to the facts of this case, including what the respondent actually did and his actual pattern of behaviour, that is how we say you get to the conclusion that he was not in fact imprisoned, even though the curfew requirement was made of him. The case involving, in fact, I think all of these cases are in Authorities 1, so if we're working from the hard copy, I ask the court to take Authorities 1. In chronological order, the first one is at the end of the bundle, at tab 16. This is MS 732. Wright and Wilson, and this is the authority that deals with the question of having a route of exit that involves a trespasser trespassing through somebody else's room to get out. The value of this case is not just because the unlawful exit route is available, but it also illustrates how, if that is available, you don't have the element of total restraint or complete constraint on the individual. I think that I think it was said in the Court of Appeal that this was an old and slightly odd case, but we do notice that this was cited by the Australian court in McFadden, one of the cases that Learned Friend cites. I'm not going to deal with those. I'll deal with them in reply if I need to, but it's not as if this case is just so old that everyone's forgotten about it. It's cited in the textbooks, cited by other courts. These remain valuable cases.
I am, of course, always critical of counsel when they refer to a court being a strong court, because all courts are by definition strong. But I do notice that this decision was by Chief Justice Holt.
Lady, yes.
So not any old judge, in other words.
Not any old judge. Next in time, go to tab 1, Arrowsmith and Le Mesurier. This is MS 483. On the facts of this case, there was a warrant granted to apprehend the plaintiff. And the constable went with the warrant to the plaintiff's house and showed it to him. And after taking a copy of the warrant, the plaintiff attended the constable to the magistrate, as is said in the report. And after being examined on the subject, the charge was dismissed about 6 hours after the time when the warrant was first shown to him. So what you have there is undoubtedly the constable could have arrested him because that was exactly what the warrant was for. But when the plaintiff sued for false imprisonment, the decision of this court was given by Sir James Mansfield, Chief Justice. Here, said the plaintiff went voluntarily before a magistrate. The warrant was made no other use of than as a summons. The constable brought a warrant but did not arrest the plaintiff. How can a man's walking freely to a magistrate prove him to be arrested? And the jury had therefore reached the correct conclusion. Now, several things to say about this. First of all, it shows that even though the individual could have been arrested, he wasn't on this occasion. He actually went voluntarily with the constable, and so he was not imprisoned, he was not constrained, and that's the central part of the decision here. And that was so, even though it seems clear that the consequence of his not going voluntarily would have been that he would have been arrested, because that, after all, is exactly what the warrant was for. Fine dividing lines, perhaps, but these are...
I think it's a bit difficult when the words of the judgment are that he walked freely.
Yes.
It's hard to reconcile that with the notion of his will being overborne.
Well, exactly. And so we say, just as there, on the evidence, he'd seen the warrant, but he walked freely and he wasn't constrained. If you have a man who's sometimes in, sometimes out, and it depends on whether or not he wants to be out, he is a man who likewise has had his will overborne, not been totally constrained.
I think we've had the debate on that.
Well, Lord, I think one thing that I could not gainsay is that there are fine distinctions in these cases, but that is why our present case is such an interesting one to judge by the yardsticks of these authorities, which, as I say, are the authorities that the textbooks rely on. I should say the Court of Appeal said that they thought that this was a suspect decision, but we respectfully say they were wrong in that. It was cited in Berry and Adamson, which is the next case that I'll look at, which our Court of Appeal accepted without difficulty, and also accepted by the Canadian case of Ferguson and Jensen, which was also not doubted by our Court of Appeal. And in the one case in which one judge did express some dissent, the other three didn't. With respect to the Court of Appeal, that criticism of Arrowsmith and the Missouri is misplaced. The next case is in the next tab 2. It's MS 485, Berry and Adamson. In this case, it was a very similar case, really, to Arrowsmith, but the officer who had the warrant didn't go himself. He sent his man to see the plaintiff, and his man didn't even take a copy of the warrant with him. As a result, the court likewise held that there had been no arrest. You will see from the second page, that's MS 486, the Chief Justice's judgment, posed the question, has he actually or constructively been arrested and kept in prison? The case of Arrowsmith and Missouri shows that he has not, so it's a direct application of Arrowsmith and Missouri, and if anything, it's a fortiori, because there was neither the actual warrant present nor the officer himself. In time, the next case is Granger and Hill. This is Authorities 1, tab 4, MS 493. While the facts that led to the arrest complained of are quite complex, for our purposes, all we need to see, I think, is what is at the bottom of page 496 in the Chief Justice's judgment. The first ground urged for a non-suit is that the facts proved do not amount to an arrest. It appears to me that the arrest was sufficiently established. The facts are that the sheriff's officer comes with a capias to the plaintiff when he is ill in bed and tells him that unless he delivers the register or finds bail, he must either take him or leave a man with him. And then at the end of that paragraph, just above the number 221, the last sentence is, but the matter does not rest there, for upon the suit being arranged, a caption fee which had been charged by the officer to the plaintiff was repaid by him to the defendants, who thereby admit the propriety of the charge. And the caption fee was, as we understand it, a fee payable by the person being arrested to the person doing the arresting. And so those facts together established that there was an arrest. And what this... Yes, I'm asked to read from the second line. Without actual contact, the officers insisting that the plaintiff should produce the register or find bail shows that the plaintiff was in a situation in which bail was to be procured. That was a sufficient restraint upon the plaintiff's person to amount to an arrest. I should say, if this is in any way unclear, we don't dispute that an arrest or an imprisonment can take place without actual physical contact. But the question is, was there a complete control, complete constraint? And in this case, you see that given that the defendant was saying that he must either take the plaintiff, or leave a man with him, that was, unlike the previous two cases, a case where there was a total constraint on him. There was actual control over the individual, either by taking him away or leaving the controlling guard with him. And it also illustrates the second proposition, which is that if the guard had been left with him, it would have been for the purpose of keeping the plaintiff in the place where he was. The next case in time is Burden-Jones, which is Authorities 1, Tab 3. It starts at MS 487. It's a rather famous case of the obstruction of the bridge and the plaintiff wanting to go through the enclosure. I think it was an unlawful enclosure, and getting stuck because he was not being allowed to proceed through the enclosure. And what the court decided was that this plaintiff was not imprisoned. You see that on on MS 488, the second page of the report. Mr. Justice Coleridge said, there was no imprisonment. To call it so appears to me to confound partial obstruction and disturbance with total obstruction and detention. So you see the distinction between the two concepts. So total obstruction is needed for detention. A prison may have its boundary large or narrow, etc., but a boundary it must have, and that boundary the party in prison must be prevented from passing. He must be prevented from leaving that place within the ambit of which the party imprisoning would confine him, except by prison breach. And on the next page, MS 489, in Mr. Justice Williams's judgment, you see that concept being picked up. It is about 5 lines below the number 748. There's a page number 748 interposed in the middle of a word. About 5 lines below that, Mr. Justice Williams says, if a person directs a constable to take another in custody, and that person should be told by the constable to go with him and the orders are obeyed, and they walk together in the direction pointed out by the constable, that is constructively an imprisonment, though no actual violence be used. In such cases, however, though little may be said, much is meant and perfectly understood. The party addressed in the manner supposed feels that he has no option, no more power of going in any but the one direction prescribed to him than if the constable or bailiff had hold of him. No return or deviation from the course prescribed is open to him, and it is that entire restraint upon the will which I apprehend constitutes the imprisonment. And in the last paragraph of his judgment, which is at the top of top of MS 490, the last sentence is, I'm aware of no case nor of any definition which warrants a supposition of a man being imprisoned during the time that an escape is open to him if he chooses to avail himself of it. Again, we say, as an illustration of the concept of total control, there's no clearer statement than that. The respondent in our case always had the means of escape open to him, and he frequently took it.
But I think a distinction needs to be drawn, does it not, between objective means of escape and the subjective mind of the individual. There may be the possibility, objectively, of someone walking out of the house in defiance of a constraint, but if that person is of a disposition that they will not defy, then it's surely entirely conceivable that his will is overborne, not because of the objective circumstances, but because of his subjective reaction to the sanction that has been imposed upon him.
Well, I don't think I can do more than to repeat the submission that I've made, that on the facts of the respondent's case, that it would be an unreal analysis of what was taking place.
Provided you can come up with a prescription for the entire period that the restraint order, or whatever it was called, detention, not detention, restraint order was in place. Well, it's a theme that I've already voiced with you, Mr. Tam, that on one day a person may say, well, I'd love to go out and engage in this activity, but I'm just not prepared to defy the instruction that I've given, and therefore my will is overborne. On another occasion, he said, well, I don't want to defy it, but I'm impelled by superior circumstances, such as religious observance or such as a wish to ensure that he doesn't imperil contact with his children. It seems to me that it's very difficult to say that you look at the entire picture and you say, because on occasions he has defied the constraints, that means that he has never felt that he's never felt that his will has been overborne. That, I think, is at the moment I'm having difficulty with that proposition.
But in any event, if the instruction had said, well, you've got to stay at home during these hours, oh, but by the way, you can take the train to go where you want to go at certain times, that would be the equivalent of this case. But the instruction says you've always got to be at home during those hours. The fact that he chooses not to obey it is obviously a point that you're making a lot of. But in terms of the Burden-Jones situation, there was always another way to go. It was as if they said, oh, you can have a secret tunnel that takes you to the family court in Coventry or whatever it is, wherever it was.
Yes,
rather like the route out
yes.
to the different bedroom.
Yes, what I'm getting from Burden-Jones is not an analogy, not a direct analogy that.
No, you are getting a concept.
I'm getting
of total
a concept
control.
of total restraint being necessary. In Burden-Jones, the total restraint was absent because there was that other way he could cross the road to the other side of the bridge, I think it was, and carry on going, or he could go back. In the respondent's case, the total restraint was not there because the features of the curfew were that he could open the door and go out, and he often did, and that's what we get. But it is that concept over and over again of total control that is necessary.
Yeah, the Chief Justice dissented in that case, I see.
Yes, he did, and it's an illustration of how fine some of these distinctions can be. Can I move on swiftly because I see that time is passing. The next one in time is Warner and Ridderford, which is tab 15 MS 720. The relevant part that I need to draw attention to is on MS 727, where Mr. Justice Williams adverted to the fact, this is at the very bottom of the page, that the plaintiff had been constrained in his own house and a restraint put upon his person by refusing him permission to leave the room and go upstairs in his own house, and that was in itself an imprisonment. So it's an illustration of that proposition that if there's a restraint, it's a restraint to keep you right there. Going back to tab 8, MS 572 is the Irish case of Phillips, where the claimant had a disagreement with the ticket collector and the station master. So this is starts at MS 572, but the facts are probably best taken from MS 573. In the right-hand column, about a quarter of the way down the page, where the plaintiff's evidence was set out by Lord O'Brien, the Chief Justice. The ticket collector, after the plaintiff's daughter had said, "I have a cab, come along," the ticket collector told me not to move. That's what the plaintiff said. I asked the cabman whom he was to obey. Was it I or the ticket collector? The cabman said, "You, but we dare not move." The ticket collector went away and brought back the station master. The station master refused to hear my explanation and said I was travelling on a false ticket. The ticket collector kept waving the wrong half of the ticket in my face. I was annoyed at this, took it out of his fingers and tore it up. The station master said that I was a dishonest woman, I was acting most dishonestly, and that I was no lady. I gave him the bits of the torn ticket and said I would report him. He laughed at that and said, "Oh, do, mum, and I will take the law on you." I got into the cab. The station master shouted, "We have the number of that cab." We drove away. Now, as an altercation, one can see the potential in that. But it's quite clear that the ticket collector had given an instruction that the claimant was not to leave, and the cabman said he dare not move. So they were stuck there for a while, but even so, that was not a total constraint that amounted to imprisonment. It also illustrates a proposition that a mere instruction would not do.
The cabman was of less robust disposition than the lady concerned.
She was no lady.
Oh, she was no lady. No.
Oh, she's definitely a lady. There was no gentleman.
And of course, the court will have noticed there was that express threat of legal action against her. But she was, despite the fact of having been detained there on an instruction for a while, it did not amount to imprisonment, and then she left. Almost contemporaneously with that, there was the decision of the Privy Council in Yusuf Uddin. This is at tab 14, MS 713. At the top of MS 716, Lord Norton identified the questions, a very short one, it really comes to this, is a prisoner who's been released on bail under imprisonment, has been released on bail under imprisonment still, so long as he is out on bail. The decision on that is on MS 718, just below a third of the way down the page. He says the whole weight of authority is the other way, that's against the appellant. Nothing short of actual detention and complete loss of freedom will support an action for false imprisonment. Leading case is on the subject is the case of Bird and Jones. So there again, clear concept of complete loss of freedom that's necessary. You see the same in Robinson and Balmain. This is tab 12, MS 652, the rather difficult barrister who would not pay another penny to get off the wharf. And on page 656, the Privy Council's judgment given by the Lord Chancellor, at the paragraph starting halfway down the page.
Sorry, could you give me the page number?
Yes, it's MS 656.
Thank you.
Clear to their lordships, no false imprisonment at all. The plaintiff was merely called upon to leave the wharf in the way in which he contracted to leave it. There's no law requiring the defendants to make the exit from their premises gratuitous to people who come there upon a definite contract which involves their leaving the wharf by another way, and the defendants were entitled to resist a forcible passage through their turnstile. So no total constraint here, because he could either leave by completing his contracted journey, or he could leave by paying his extra penny and going back the way that he'd come. Nearing and Graham White Aviation is the next case in time. This is tab 6 at MS 548.
It's quite relevant in Robinson and Balmain Ferry, isn't it, that was the contract to which he had agreed. It's rather
yes.
like the Hurd and Weardale miners case.
Yes.
They weren't imprisoned by being kept in the mine during the shift which they'd agreed to work in the mine,
Yes.
as I understand it.
That's right.
So the contractual element of that was an important part of the decision in both cases, wasn't it?
I accept that, and the contractual part means that, or afforded one form of egress from the situation in which he was. But of course, what he wanted to do was to leave the wharf by a different route from his contracted route. He was in a situation that was like Bird and Jones. He was stopped from leaving the wharf, but again, he had the egress available there by paying the extra penny.
I mean, one way of looking at the Robinson case is it's more about whether it was false than whether it was imprisonment. And the wharf owner had a contractual right to require him to leave in a particular way, and therefore there was nothing unlawful in insisting on that contractual right.
Yes, well, the way we analyse it wasn't even imprisonment because he had the routes of egress available to him.
Yes, I simply wonder whether that's the right analysis.
The next case is Mearing and Graham White Aviation, tab 6, MS 548. The critical part of the facts of the case were the point at which the plaintiff had been taken back to his employer's office. He was suspected of theft, taken back to his employer's offices and taken into the waiting room. And outside the waiting room, there are a number of works policemen who were waiting outside and had stayed on duty to make sure that he didn't leave. The jury found that the plaintiff had been imprisoned, but for our purposes, the important thing is the way that Lord Justice Atkin analysed the potential situations. And this is on MS 558, at the bottom of the right-hand column, where he said, "It appears to me that there are no doubt two inferences that the jury might draw from these circumstances. They might come to the conclusion that all that happened was that Prudence would have restrained the liberty of the plaintiff if the plaintiff had sought to exercise his liberty by proceeding to the cottage. But they might, to my mind, infer also that Prudence had made up his mind from the time that the plaintiff was in the waiting room that he should not exercise his liberty and that he placed the policeman there for that purpose." So in the first one, no imprisonment, even though he would have been imprisoned if he tried to leave. And in the second, that he was already imprisoned because he was not going to leave. The jury had found the latter, and there was evidence that they were on which they were entitled to do that. but it's the analysis that there is a possible fine distinction between those two situations that is important. So that illustrates that the need for a constraint, and the proposition that if there's a guard or something to keep you, it has to keep you there in place where you are. And also that if there is an adverse response on the alternative hypothesis, that is to say, if you try and leave, you'll be arrested. That doesn't mean that you're already arrested. I'm not going to turn up O'Brien and Jensen, or Ferguson and Jensen, the Canadian case, because it is actually very, very similar to Arrowsmith and to Berry and Adamson, because I do need to ask you to look, please, at the only really modern authority on this, which is Ex parte L, and this is tab 11, MS 610. The claimant here had been causing problems. If you look at MS 631 in Lord Gough's speech, you will see the relevant history set out. The plaintiff had been given a sedative. He became calm and relaxed. He was taken back to the hospital, became agitated, and he was transferred to the behavioural unit at the hospital. The consultant decided that he should be readmitted for inpatient treatment. She considered whether it was necessary to detain him, but decided that it was not necessary because he appeared to be fully compliant and did not resist admission.
By detention is there referring to invoking the powers in the Mental Health Act?
Yes, it was.
It's not being detained as a matter of fact.
Not detained as a matter of fact. That would have been, the question was, did he need to be sectioned? Going on to MS 638, you will see Lord Gough between letters C and F citing some of the authorities that we'd already looked at over what common law detention or imprisonment might involve. Over the page at 639, just below letter F, there's a citation of the consultant's evidence, which includes 6 lines up from the bottom of the quotation. If he'd resisted admission, he would certainly have detained him under the Act, so that he would then have been sectioned. And the relevant part of Lord Gough's speech, for our purposes, is then on MS 641, the last paragraph starting just below D. The readmission as an informal patient could not constitute the tort of false imprisonment. His readmission did not constitute a deprivation of his liberty. He was not kept in a locked ward, and the fact that she had it in her mind that she might thereafter take steps to detain him compulsorily under the Act did not give rise to his detention, in fact, at any earlier date. And so there was, in the view of the majority here, it was a 3-2 majority, no detention at all, although they all agreed that there was the defence of necessity was made out. And so that, we say, also illustrates these propositions, that just because you might be arrested or detained or something if you choose to leave doesn't mean you're already detained. I seem to recall that Lord Stone regarded that as a fairy tale. Yes, I think that's how he put it. You'll see that in it's MS 647, just above letter E. But the majority decision was a decision of their Lordship's House, and that was the law. It illustrates these distinctions. So these are not novel or restricted propositions that we're putting forward. These are firmly based in the authorities that are cited in the textbooks as the foundation for the simple tests that they set out that apply to most situations. But applied to the respondent's case, he was not locked in, there were no guards, he was instructed to stay in, and he could choose to comply or not to comply, and as a matter of fact, he did both at different times. and it is proper to describe it as his decision whether or not to comply. Second, there was no other physical constraint. Even if the threatened consequences had been triggered, they would not have been of a kind that kept him within his own home. The original curfew might have done that if it had remained in force, but the consequences, the arrest, the prosecution, and the possibility of redetention would not have kept him in his own home. The third, the constraint was neither total nor complete. He had an escape route. In this case, it was just by opening the door and going, and he repeatedly used it. All of that is inconsistent with his will being overborne during the period. The fourth, the adverse consequences that might have followed would not be the type of consequences that would constitute constraint for the purposes of false imprisonment, because it's basically ex post facto legal action. And the fifth proposition is that even though it might have been unlawful, or apparently unlawful, for him to go out, that in itself doesn't mean that the imprisonment is made out. Before leaving the common law, can I just briefly mention two sweeping up points? The first is open prison, which my learned friend suggests that this is akin to. There are important distinctions between this and an open prison. First of all, a warrant of imprisonment specifies that you are to be detained. And that governs everything that happens to you whilst you are in prison under its authority. It would be authority for your detention in undoubted imprisonment, and the fact that you are at a particular time allocated to a less secure institution doesn't change the fact that you are imprisoned under a different kind of legal process altogether from a curfew requirement. And that's even before you start looking at the consequences of committing criminal offences if you escape from an open prison. But the second difference is that there is a specific statutory provision for prisons which deems you to be in custody whenever you are in prison, even if it's an open prison. And can I just give you the reference for that? It's the case of Montgomery, Authorities 4, tab 45, MS 1567, and there is a quotation, a quotation at paragraph 13, MS 1572, of section 13 of the Prison Act. So that applies to all prisoners in open prison. And the other sweeping up point is the point about the reduction of a criminal sentence if you've been on a curfew whilst you've been on bail. It's open to Parliament to provide for a reduction in sentence for any sort of disadvantage whilst you're on bail, if Parliament chooses to do so. We don't deny that the curfew requirement did constitute some disadvantage or constraint. But it's a non sequitur to say that just because Parliament says that your sentence can be reduced, therefore the disadvantage in bail was something that amounted to imprisonment. Parliament could have said, well, if you couldn't travel overseas while you're on bail, you'll get 2 weeks off your sentence. And the two simply don't correlate. So there's nothing in that point either. May I, with my learned friend's consent, then leave the common law, because that completes the submissions I wanted to make on that.
You've already stepped the limit of the time that you
Yes.
allotted yourself.
I've asked my learned friend about this because I've spent some time answering questions from the bench.
You have to take that into account.
My learned friend would be happy if the court is happy for me to spend just a few extra minutes and take it out of the time that I had for my reply, and to cut that short accordingly.
That is
may I ask for that indulgence?
Well, we normally are perfectly happy with that, as long as the opposition are happy with it. And Mr. Rose looks reasonably content. Yes. So, yes,
Well,
you may continue.
I'm very grateful. And just to say a few words about Article 5. The starting point is our proposition that as far as Article 5 is concerned, the respondent was not deprived of his liberty for Article 5 purposes. And we get this from the decision in JJ, the control order case, which is Authorities 1, tab 13 at MS 658. Now, this was a 3-2 majority decision on whether an 18-hour per day curfew constituted a deprivation of liberty for Article 5 purposes. The House was divided on that, and then there was a further disagreement about whether the House should specify a particular dividing line, which Lord Brown had suggested should fall at 16 hours curfew. I don't need to say that that is right, but those two facts put together show where the House, or what the House was thinking as the broad location of the dividing line between deprivation of liberty and not. So the line is somewhere near there, 16, 18, 14 hours, whatever it is, depending on the facts of the case. That's a long, long way from the respondent's case, which was an 8-hour per day curfew. What learned friends seek to do, though, is to take some words from Lady Hale's speech out of context as somehow saying that there was a deprivation of liberty during the curfew hours. That is in paragraph 61, MS 697. The paragraph starts, undoubtedly these people were deprived of their liberty during the curfew hours. Did the fact that they were allowed out for up to 6 hours a day make any difference? And it's suggested that that means that during the curfew hours in the respondent's case, he was deprived of his liberty for Article 5 purposes, and therefore it makes no difference. But that ignores what the case was all about. As Lady and Lord Sales will remember, the legislation allowed two types of control order: a derogating control order, which, if a derogation was in place, allowed a control order that deprived people of their liberty for Article 5 purposes, and a non-derogating control order, which could not deprive anybody of their liberty. There was simply no power to deprive of liberty. There was no derogation in place, so the non-derogating control order was the only type that could be made. And so if the curfew was short enough, then the individual was not being deprived of their liberty at any time during every 24-hour period, because there was no power to do that. And while the JJ case was one where it was held that they were, there were many control orders which didn't, even though they involved a curfew. And that's why we say that at 8 hours, there was plainly no deprivation of liberty for Article 5 purposes in the respondent's case. At paragraph 7.1 of our case, this is MS 110, we've set out the history of this particular issue of whether Article 5 might be aligned with, Article 5 deprivation of liberty might be aligned with common law imprisonment. And I don't need to go through that. The current position up to Court of Appeal level is that you can be imprisoned without being deprived of your liberty, and you can be deprived of your liberty without being imprisoned. Ex parte L is in fact one of the examples of the latter situation. And as the court knows, and as we've set out in our case, one of the consequences of Ex parte L and its successor decision in Strasbourg, HL, which is Authorities 1 tab 5 MS 499, was that the Mental Capacity Act, Section 64, made a provision that basically put the Article 5 deprivation of liberty into that statute, as explained by Lady in the case of P, authorities 4 tab 49 MS 1592 at paragraphs 2 to 8. So there is this question about whether it would be better to go there. Parliament has gone there in that case. I need to be candid about this, and we've been candid in our printed case. There are some difficulties with doing this, but the possibility is open to this court. The difficulties were recognised as including that the defences to the two claims would be different. This court has declined to do this in relation to Article 2, although a similar invitation was made there. It's possible that, like for the Mental Capacity Act, this is something that only Parliament should do. And as the Court of Appeal in our case pointed out at paragraph 31, it is open to a state to be more generous to an individual than the flaw of ECHR rights. But we do advance it because it is open, it is a potential solution to the conundrum raised by this respondent's case, or what do you do about a person who chooses to go out when he's out and recognises he's not falsely imprisoned, but then says, well, any time I'm in at home, I am being falsely imprisoned, and complains that at that stage he's totally and completely restrained with his will completely overborne. And the one thing that we can say, properly say about this, is that given that this is not a situation of an Article 5 deprivation of liberty, we say that the court should not extend common law false imprisonment to include the respondent's situation. Despite the curfew constraint, if you take a step back and look at everything that happened to the respondent and what he did, he never had to say, help, let me out. He was clearly not imprisoned, and there's no warrant for extending the concept to include that in this case. I'm grateful for the extra time. I'm grateful to my learned friends' indulgence. I think my voice is giving out anyway. Unless I can assist any further, those are our submissions.
Thank you very much indeed, Mr. Tam. Mr. Gullick? Well, we dock 10 minutes from your reply time. Ms. Ray.
My lady, my lords, can I first go back to the actual restriction that was imposed on the claimant in this case, which you have already seen. I just want to go back to it. It's in the appendix at tab 26, and the MS page number is 403. So the facts are that the claimant has recently, the day before in fact, been released from immigration detention by the tribunal, which has granted bail, and in accordance with the bail condition, he attends upon an immigration officer, and at that point, his bail terminates. And the immigration officer serves on him this document headed Notice of Restriction. And what it says is, the Secretary of State has decided that you should not continue to be detained at this time, but under paragraph 2.5 of Schedule 3 of the 1971 Act, she now imposes the following restrictions on you. So he is being told that under a statutory power, the Secretary of State is imposing restrictions on him. And the restrictions are then set out, and you see at paragraph 3 that he must live at a specified address, a particular flat. Then at 4, in capital letters and in bold, you are to be monitored electronically by means of tagging tracking. And then at 5 is he has to attend for induction with his tag. And then at 6, again, highlighted in bold, following induction, you must be present at the address shown above between the hours of 2300 hours to 0700 hours AM every day, and every day thereafter between the hours of 2300 hours to 0700 AM. And then If without reasonable excuse you fail to comply with any of these restrictions, you will be liable on conviction to a fine not exceeding the maximum on level 5, currently £5,000, or imprisonment for up to 6 months, or both. So he is told that the Secretary of State has decided to impose that restriction upon him, that he must stay within the boundary of a particular defined premises between those hours every day, on pain of prosecution and punishment, either by a fine or by imprisonment or both. And, my lady, those are the facts on which, at the invitation of the parties, the High Court decided that there was imprisonment in this case. Because, as the court knows, the High Court heard 2 hearings in this case, and it decided the issue of false imprisonment at the first hearing. That was before it took evidence from the claimant, which has exercised so much of Mr. Tam's submissions. The question of the particular dates and the particular times at which the claimant was absent during curfew hours was not advanced by the Secretary of State as a reason why this was not false imprisonment. It was advanced at the second hearing on the question of damages. And indeed, the way that permission to appeal was sought in this case was not on the basis that on the facts of this particular case, this individual claimant's will was not overborne because he was prepared to go out whenever he felt like it. The way it was advanced was that this was a matter of general public importance because the Secretary of State required a ruling on the question of whether this type of curfew imposed by this type of restriction notice constituted imprisonment at common law. And the court can see that if you just go to the core volume. It's in the notice of appeal. It's at MS 14, paragraph 1.5. The issue, says the Secretary of State, is one of general public importance because for some years curfews have been commonly imposed as a condition of release from immigration detention, as a measure which can reduce the risks of absconding and reoffending. A curfew is often imposed as a condition of bail in criminal proceedings. Consequently, it's of some importance to know what are the legal effects of an unlawful decision to impose a curfew. But the way that the case has been presented to the court by Mr. Tam is essentially fact-dependent on the way that he characterises the facts of this particular case. And he says this particular claimant, on the facts, his will was not totally overborne because there were occasions when he left. Now, in our submission, that is not an accurate characterisation of the facts. It's not an accurate characterisation of the facts that were found by Mr. Justice Lewis, and they were found, of course, at the second hearing after he'd already decided that this was false imprisonment. And neither is it an accurate characterisation of the evidence which was accepted by Mr. Justice Lewis and which was the basis of the facts that he found. In our submission, the way that the case is put forward is also wrong in law. I'm going to turn to that in a minute, but just now, can I just show the court the relevant factual findings of Mr. Justice Lewis and the evidence on which those findings were based? The key finding in the second judgment is at MS 199. It's paragraph 23 of the judgment. Claimant gave oral evidence about the effect on him of the curfew. He explained he did not want to return to detention or be fined. He was worried when he had come back late to his home or when he was absent during the curfew about what the Home Office would do, and it played on his mind for weeks. He said in his witness statement he could not work or study as a result of the deportation decision.
He was already severely restricted in what he could do. As a result of the curfew, he suffered deeper depression. The implication is he was already depressed as a result of his immigration position. And then after discussing the issue of his depression, the judge finds that on the balance of probabilities, the curfew added, but only to a limited degree, a very limited degree, to the depression he was already suffering as a result of his immigration position. He said he took steps to ensure that he did comply with the curfew, but felt he should attend his mosque for religious observance and attend the family court proceedings, but was worried he'd be detained or fined. He did not attend certain community gatherings or parties because he was worried he'd be late back. I accept that evidence. I find as a fact that the claimant did broadly seek to comply with the curfew. Now, those are the findings, and we submit that they do not support the way that my learned friend has characterised this as, oh, well, he just chose to go out when he felt like it. And in fact, Mr. Justice Lewis is there making clear that he accepted the evidence that was given by the claimant, and the...
Sorry, just before you put it away,
Yes, my lord.
I raised paragraph 22,
Yes, my lord.
Mr. Tam, in the middle, where it says on 6th of July, the Home Office, 2015, the Home Office declined to grant the variation as the claimant had failed to comply with the curfew.
Yes, my lord.
Do we have the documents of that? Do we know what...
We don't now, my lord, but those materials were before
Yes.
Mr. Justice Lewis, and it's right. The evidence was that there were requests were made for permission for him to attend the family proceedings, and no response was received from the Home Office. And his solicitors advised him to go in any event. And I'm going to show your lordship that evidence in a moment.
Yes.
But it's right to say that there was an occasion, there was one occasion in 2014 when he was given permission to be absent during Ramadan, but then there was another occasion when that permission was refused.
We don't know how formal it was or whether it said...
My lord, there would have been evidence about it, but I can't for the moment recall. Can I just show your lordships the key passage in his cross-examination?
I mean, it does seem to be on one view,
Yes.
which you might say this was intended to be a effective restriction, but
Yes.
it wasn't very competently administered.
Well, Lord, that wouldn't be the first time from the Home Office. But my Lord, I'm going to come on to the legal framework after the short adjournment.
Yes.
But can I just finish by showing your lordships the key part of the evidence that was being accepted by Mr. Justice Lewis in the paragraph 23 that we've just looked at. And if you take up the appendix and its internal hard copy numbering 317, the MS numbering is 464. So this is Mr. Jalloh's cross-examination by Mr. Tam. And you can see that Mr. Tam puts to Mr. Jalloh, just under the letter B, the case that he has advanced before this court. He says, the answers you've given today about these occasions on which you were out during your curfew demonstrate that if you wanted to go out, you just went out, didn't you? And if you wanted to stay out, you just stayed out. And he says, yeah, good question. This is what I was waiting for. Sir, so you know, like I said, I took this curfew very, very serious. And then because I'm scared of it as well. I'm scared of because I know where I've been. Detention, in prison. And in my mind, if I breach it, I know where I will go. So I know that. I know I've been there. I've been there many, many times, and I do not want to go back there. So the first year I was on curfew, every time I go out, it's not because I feel like I can just breach it. No. It's when I don't have no choice, like going to my family care proceedings. That one, like my family care proceedings, was going on for 2 to 3 years. I always have to go to court. It's a complicated case. We write to the Home Office. They don't respond back. And then my solicitor says to me, Mr. Jalloh, go. The Ramadan time, even if I wanted to go to prayer, I swear to God, my solicitor said to me, go. Then because my solicitor said, just go, I thought, okay, if I go, whatever the Home Office done to me, my solicitor is there to help me. So I went, you know. So I took this, and I swear to God, I was one of the main people, I swear to God, the one that took it serious and complied with this. I actually did comply with this, you know. I did comply with this every time. It would have been for a reason. I know that for sure, because I remember see me running back on my daughter's life, running back from the bus stop to my house, running. I get off the bus, I'm running, I'm speeding hard, just to get to my house, And then I came and then they ring me. They say, Mr. Jalloh, sorry, you was 10 minutes late. And this now plays in my head, for 2 weeks. I'm thinking, what's they going to do to me? That's what I'm saying, big man. Come on, man. And I want to just say this as well. I want the judge to understand, and I've been hearing that's a different matter, talking about the case. I want the judge to consider this curfew. It wasn't for 2 weeks. It wasn't for 3 weeks. It wasn't for 4 weeks. The judge says 891 days. And he says, yes, it was for years. Even when people get tagged by the judge for what experience, when they go to tribunal and you get tagged by a judge, I swear to God, the understanding of the judge is they'll be deported in the next 4 weeks. We're still here 4 years later. Come on, man. Now, that in my submission gives you a much more vivid impression of what it was actually like being under this curfew and being under the fear of the consequences of breaching the curfew. And I mentioned earlier the point about them phoning him in the night. And you can see that it's at page 458. So it's just opposite letter A. Sometimes at night time, there's many, many times where G4S, they ring us, they ring me on my phone, and they go, where are you? And I swear to God, I'm in my room, and they're asking me, where are you? Many, many times, and I'm telling them, I'm here, and you're ringing me asking where I am. I'm here, I'm not going nowhere. Then a couple of days later, or 4 days later, they'd come and fix some battery, ask me to walk around, go to the garden, go to the bathroom, put my leg in the bath. So it always happens. For some reasons, the ones I can't explain to you. So he says there's some technical fault. And then at 459, just below A, sometimes they ring me back. If they ring me back because I'm trying to sleep because I've got the box was in my room. I don't want my housemate to know my situation. I'm on curfew. Then I have to hide it next to my drawer. So it's noisy. They're ringing me. I'm picking up. I'm telling them I'm here. Then they're ringing me back. Then sometimes I just don't pick up because they're ringing me and I'm saying I'm here and they keep on ringing. And I'm like, come on, man. So in our submission, the question for the court is, given that the Secretary of State now accepts that there was no lawful basis on which the restriction notice could have been served on Mr. Jalloh and enforced in the way that it was by electronic tagging and the associated phone calls and warning letters, was that conduct by the Secretary of State imprisonment? And our submission is that the answer to that question is straightforward. This is a clear case of imprisonment at common law. And our central submission is that the judgment of the Court of Appeal in this case is correct for the reasons that it gave. We also submit that the judgment of Mr. Justice Eadie in Geddy, although very succinctly expressed, encapsulates the relevant provision and is entirely correct. You saw that a little earlier. It's in the first authorities bundle at tab 9. It's MS 575. And it's paragraph 67. False imprisonment is the unlawful imposition of constraint on another's freedom of movement from a particular place. I've used the expression house arrest above. It appears to me that for the state to threaten a person with imprisonment if he leaves his home is plainly a sufficient constraint to constitute this tort. In my submission, that is a correct statement of the law, and I shall explain why at further length. Now, the way I would like to proceed is first to endeavour to summarise to the court what in our submission are the correct legal principles that apply to the establishment of whether there is imprisonment at common law. Second, to identify the key statements in the authorities from which we derive those principles. Third, to apply those principles to the facts of this case.
and finally to identify the key flaws in the argument of the Secretary of State. Now, it's about 2 minutes to 1. I don't know if your ladyship would like to take lunch perhaps slightly early and then start again at 3 minutes to 2.
I'm absolutely sure that that would be what we would like to do. We might even just start at 2.
Well, my lady, we're in your hands.
Well, we will try and be prompt at 2.